My name is Natalie Clayton, and I'm a partner in the IP litigation group here at Alston and Bird. The group is composed of approximately 100 attorneys coast to coast in almost all of our offices. And one of the things we think sets our team apart from other firms is that we really understand how to litigate a case to have it trial ready. We not only understand the science and the technology surrounding these complicated cases, we understand how to speak effectively to judges and juries at trial. And that's what I would like to focus on today, how to make sure your patent case is trial ready. And the first aspect of trial strategy I would like to discuss today is making sure that you effectively preserve your witnesses' credibility, and that is with regard to both fact and your expert witnesses. One of the most important things in preparing for trials to ensure that throughout the case you preserve your fact witnesses' credibility. And this really begins at the beginning of the case with the fact witness depositions. It is very important that at the fact witness deposition they tell the story that they are going to tell at trial, and that it remains consistent throughout the rest of the case. All too often, fact witnesses are told to shut down for deposition, to have a memory failure. But then trial comes and that same witness is told to tell a compelling narrative in great detail. But when that happens, when the fact witness's story changes drastically from deposition to trial, they will have lost credibility. And so it is very important for the lawyers to ensure that all fact witnesses' stories remain consistent from the very beginning of the case to the time they leave the stand at trial. In addition to maintaining the credibility of your fact witnesses, it's equally key and perhaps more important to have your experts maintain their credibility. And there are two things that typically plague expert credibility. It is crucial for the expert to fully understand the opinions they are offering in great detail and understand how those opinions might affect other aspects of the case. If they don't fully understand those opinions, and if they have simply rubber stamped what the lawyers have told them to say at deposition or trial, that expert will invariably crumble because they will be presented with contradictory information or previous positions they have taken that undermine the positions that they set forth in their expert report. Therefore, to maintain their credibility, it is crucial that the lawyers sit down side by side with the expert so that the expert really understands the positions they are taking and that they can stand behind that testimony at trial. It's also equally important to make sure that expert doesn't go one step too far, that they don't take that next step, make that unnecessary opinion that undermines all their credibility. It's the lawyer's job to make sure that the expert doesn't get too cute with that one last and additional argument and that they aren't straining the boundaries of reason. The next important consideration when preparing for a trial is that you need to come in with a very clear, concise narrative to present to the judge and the jury. Patent cases involve highly technical, complicated concepts, and you need to find the arguments and the themes that your average person can digest and understand. All too often, lawyers want to make every argument, they want to present every detail to the judge or the jury. But trial is just not the place for those tendencies. And personally, I have found the best way to test these themes and arguments is through the mock jury exercise. When done effectively, and yes, there are wrong ways to conduct a mock jury exercise, they provide you invaluable information about the themes and the arguments that are going to most effectively resonate with the judge and or the jury at trial. It tells you which arguments to keep and which ones to get rid of. The next thing I would like to talk about is how important it is to devise a clear, concise narrative to present to the judge and jury at trial. Presenting a clear and concise narrative to the judge or the jury also falls directly in line with the next point I want to make, which is although we are presenting highly technical concepts to the jury that must be explained in a way they can understand, it must also be done in a manner in which they do not feel like they are being spoken down to. You must present it in a way that gives them enough detail and recognizes that they are contributing to the conversation and issues at hand. And again, the mock jury exercise is the perfect place to help determine whether or not the demeanor of your presentation is effective with the jury. Are you dumbing the content down too much for the jury? Do your fact witnesses and experts speak in too condescending a manner to them? The same might be true of your lawyers. The mock jury exercise will give you the answers to these questions. And the answers to these questions are vital to know before you walk into that trial courtroom. After all, hundreds of millions of dollars are typically on the line. The last point I'd like to discuss is how important and valuable it can be to get local counsel involved who has significant trial experience in the jurisdiction you are in. After all, in some jurisdictions like the Eastern District of Texas, if you walked into trial without local counsel by your side having a meaningful role, my bet is that you would lose. And while in other jurisdictions, local counsel trial participation may not be as important, it can still vitally contribute to your outcome. I have found that local counsel knows the tendencies of local jurors. They know what themes are going to resonate, and they know the preferences of the judges. So in my experience, getting local counsel involved in a way where they have a stand-up, meaningful role at trial is invaluable. These are just some of the considerations that you should take into account when preparing your case for trial. Alston & Bird's IP litigation team has tried cases in every important patent jurisdiction around the nation. Alston & Bird's IP litigation team is prepared to help your company put together an effective trial strategy for any venue in which you find yourself.